Thank you, everyone, for joining us today for a very exciting lunch and learn on insurance training, claim scenario, and mock trial with Bryden Barbee, Director of Risk and Claims. So before we hand it over to our guest of honor today, I'd like to go over some upcoming events that you may be interested in. So first up is our NIG forum registration. It's now open, so we encourage you to register. We also have an April 13th emerging and young professionals roundtable and lots of great learning topics there and camaraderie. April 28th through the 30th, we have our NIGP VCon. So this is technology and innovation, and you also get a handful of contact hours, as you can see there, 25 and a half contact hours, and it's $199 per member. On May 6th, we have another Lunch and Learn event, so please keep your eyes peeled for that. And on June 10th, we have Legislation and Legal Environment Competency Module, and that is a virtual training. So you can find all the details on our event calendar there. And some general housekeeping before we get started. Please mute yourself so everyone can enjoy the presentation. We also ask that you make sure that your name is updated in your participant kind of Zoom records so that we can ensure that you receive attendance credit. And if you have any questions, you can navigate to the reactions button there as shown in the green square or rectangle on the screen and raise your hand, or you can use the chat. We'll be monitoring that. And so without further ado, I'd love to introduce Bryden Barbee. Bryden has over a decade of experience in the insurance industry, where he's developed a diverse skill set across various roles. And beginning his career at State Farm, he was appointed to the inaugural First Line Leader Council in 2019. And this is where he collaborated directly with executive leadership on key initiatives related to organizational change and enhancing employee morale. During his last 5 years at State Farm, Bryden led a team of 15 claims adjusters and gained invaluable experience in team management and claims operations. Bryden started at the Risk Pool in 2021. He was promoted to Director of Risk and Claims in June of 2025. Please join me in welcoming Bryden. Bryden, thanks for joining us.
Thank you for having me. I'm going to go ahead and share my screen. So today, what I want to do is, as previously mentioned, I want to talk about claims. It's not the most fun topic to talk about, but I think you guys will kind of learn a lot when we kind of reverse engineer some of these claims. We'll talk about maybe what went wrong, how these claims could have been prevented in the future. So that's what we want to talk about. At the core, really, it's what constitutes a claim and how can we prevent a claim? So risk management basically is our core topic today. So maybe some of you may have seen my presentation with my boss, Chuck Boyd, almost probably a couple months ago up in Everett, and where we presented on contracts. But I wanted to just kind of give an overview of the risk pool. I'm part of Washington County's risk pool. There are other risk pools in the state that serve similar functions. There's a cities pool, there's a transit pool. So there's other pools that do similar things that we do. So we're basically kind of like an insurance company is what you can think of us as. We were formed in 1988. We handle liability, property, cyber, crime, and terrorism. We do not handle workers' comp, health benefits, public records, those sorts of things. So what we do mainly is like I said, we're kind of an insurance company, but we try to prevent claims. It's kind of one of our core duties. So we do risk management at our core. So this map, you can see kind of all in the green are all the counties that are part of our pool. In the white are all of those that are part of either a different pool, the white, or the gray self-insured. So King, Pierce, Snohomish, Kitsap, those are all self-insured. Okay, so before we get into the claim scenarios, I want to talk a little bit about negligence and what negligence is. And we'll talk about Washington State tort law, and I promise I will not bore you. We'll go through this and I'll make sure that it's kind of clear. so that you can understand it. And then we'll go over, I think we'll have that, in order to go over the claim scenarios, we need that baseline foundation. So we'll cover negligence and tort law first, and then we'll talk about these claim scenarios. And the claim scenarios, what I'm looking for is, I'm looking for participation. So I'll ask if anybody, wants to raise their hand, and hopefully the host or other staff can help point out those that have raised their hand, and then you can unmute and kind of tell me your thoughts on those claims. And then we'll talk about, okay, how could we have prevented this from happening? And then we've got quite a bit to go over with these claim scenarios. And we'll talk about also how much they're worth. And then we'll go over employment liability. I mean, that affects everyone. Employment liability, everybody works with somebody. Unless you're kind of just, even if you're working from home, you can be affected by employment liability, right? So everybody's impacted by that. And then some key takeaways. One other thing I'm going to talk about, and I think you guys requested that we discuss cyber. So we are going to go over cyber. I'll give you a claim scenario, and all of these scenarios that I cover are true scenarios. They actually happened. And the cyber scenario happened to one of our member counties. So we'll talk about that. And if you see an email from me later on today asking for a wire transfer of $100,000, it is not April Fool's. Do not click on the link. I'm not sending you an email, so just FYI. But we'll talk about phishing, some of those things. All right, liability exposures. These are common to county, but they may be common to your agency, city, state government. Road operations is one of the big ones for us counties. You may have those as well if you're a city. HR and employment, we talked about that. Property, building leases, cyber, facilities. I know cities and counties definitely have law enforcement. That's one of the most severe, or can be the most expensive type of claim. Parks and recreation, transportation, use of vehicles, obviously crime and fraud. All right. So what is negligence? In order for somebody to bring a negligence claim against an entity, they have to prove 4 elements. The first is duty owed. So what duty did we owe in this situation? Did we owe a duty? We're involved in several claims right now where we're arguing we didn't even owe a duty. And that might be because we had immunity. So that's an affirmative defense. So that's the first element, is, did we owe a duty? The second is, did we breach that duty? So did the county or government employee actually breach that duty? If no duty was breached, we don't really have a claim, right? We would deny that claim. The next is proximate cause. So duty owed, duty breached, proximate cause. So was the duty, the breach of the duty, the actual cause of the damage to the claimant? Was that the actual cause? That's what we have to investigate and figure out. And once we pass that third element of proximate cause, they actually have to have damages. So a great example of this is, driving right out here on Montman Boulevard, I could rear end somebody, and I have a duty to maintain a safe distance from that car in front of me. But if there's no damage to their bumper, there's no claim, right? They have no damages. And that happens from time to time, right? So that's what we're looking for, is the last element of damages. And we have to look at what type of damage as well. So just quickly kind of moving on to tort law as it relates to what we're going to talk about today. So it's important that you understand how tort law can affect government and affect how these claims actually play out. So the first one is a statute that refers to a claimant filing damages. Before they file damages against a government entity, there's a 60-day, I guess, cooling down period. So they file their tort claim, 60 days expires, now they can file a lawsuit. So it's kind of a cooling down period is the best way to describe it. And the whole point of that is to try to get a claim to settle before we get to a lawsuit. So that's an important statute. The next statute is really the legislative body of the government entity determines whether or not they defend an employee. And that actually kind of sounds scary, doesn't it? Like, hey, I'm named in a lawsuit, and so is Thurston County. Is Thurston County going to defend me? Well, it's up to the governing body, the legislative body of Thurston County, to make that determination. Joint and several liability. So we'll talk about joint and several liability, and I'll give you an example kind of in the next slide. So kind of hold that piece of it. The other part of it is no tort cap. So in Washington State, there is no tort cap on damages. What does that mean? I don't know if you've been watching the news recently, but I see lawsuits on the news and what they settle for all the time. Maybe on King 5, Como, YouTube, whatever, wherever you get your news, you're probably inundated with lawsuits. Like, hey, the city of Seattle settled the Chaz Chop lawsuit for, I think it was right around $40 million, right? It was the kid that was, he was in Chaz and the Chaz Chop zone, and he was shot and killed, and his dad sued the city of Seattle for failing to protect him. And a jury awarded, I think it was about $40 million in that lawsuit. So with no tort cap, the jury could have awarded $500 million, right? Because there's no cap on damages. That's what that means. The next tort law is prosecutor consent to appoint outside counsel. So this really isn't super important for you all, but basically for us, remember counties, the elected prosecutor is the one that decides on outside counsel. And that's an internal process typically. So this is a really, really, really important concept to understand. Joint and several liability. And this is why it makes defending claims in Washington State extremely difficult. This kind of illustrates the difference between joint and several liability. So in this case, we have defendant 1, defendant 2, defendant 3. And let's pretend for this example, we have another innocent party over here, the plaintiff, right? The plaintiff is an innocent party, and the plaintiff was caused harm by defendant 1, 2, and 3. So the whole point of joint and several is regardless of the fault of these 3 defendants, they are liable for 100% of the damage. So as the innocent, fault-free plaintiff, I can choose whether I want to go after defendant 1, defendant 2, or defendant 3 for my damages. Even if defendant 3 is 1% at fault, I can go after defendant 3 and say, hey, defendant 3, you work for the city of Burlington, you work for the city of Spokane, or the city of Seattle, or you work for Spokane County. I'm going to go after you for the damages because I know Spokane County has deep pockets. So something to think about. And that really plays a big factor in how we settle these claims. All right. So here's the part where I want some participation. But what we'll do first is I'll briefly kind of cover the claim scenario. And I want you guys to take a little bit of time on your own to think about some risk management, what this claim might be worth, kind of what went wrong, maybe some information that you want to know. But the first scenario is an agency vehicle in a known corridor. So an agency vehicle made an illegal U-turn on a stretch of highway known for serious crashes. The claimant's vehicle rolled over, resulting in significant injuries to the driver. A young child in the back seat sustained minor injuries. What was known before this incident? And again, this is a real incident, and I don't mean to pick on city or DOT, but we, as counties, we try not to pick on counties as much as we can, but we're not perfect either. So what was known before the incident? The corridor had a history of severe crashes. Prior crashes and claims had occurred along that stretch. The roadway narrowed significantly in that section, and roadway widening improvements were completed later after they received legislative funding. So take maybe a minute to 2 minutes maybe jot down some thoughts or ideas, and then I'm going to ask for anybody to share those ideas. So let's take about a minute or 2 minutes.
Hi, Bryden. Sorry to interrupt. I was
Yeah.
just wanting to confirm if you wanted to handle questions during your presentation or after. We did receive one in the chat.
Oh, we have one in the chat. We can do it during. Yeah.
Okay. It's from Jason, who asked, in duty owed, you mentioned laws. Would this include contracts creating a duty owed?
Absolutely. Yeah, that's a great question. So with contract law is a little bit different, but you have to really pay attention to how the contract is written, specifically the defense and indemnification, because that tells who's going to be liable for what. So we talked about this in the contracts training, but depending on how that indemnification and defense and hold harmless clause is written, an agency can take on all the can be mutual liability, or you're transferring that liability to another party. So it's really important to analyze how that's written. So that's a great call out. Yeah.
Thanks, Bryden, and thank you, Jason. And next we have, is the claimant the plaintiff? And I take it the agency is the defendant in this scenario.
Uh-oh, it looks like Bryden might have just dropped off for a second there. Um, he froze for a second and then it dropped off. Hopefully he joins here in just a second. But yeah, I believe that well, Maya, I saw you
Oh,
come off mute. Oh,
Oh,
hey, you're
yeah.
back.
oops.
Okay.
Sorry. I don't know what happened. Just went blank all of a sudden. Sorry about that.
No worries. Glad
Not
you
an
got to
April
get back.
Fool. So I don't know if you guys heard me, but as I was saying, it's been a couple minutes. Does anybody have any thoughts on this particular scenario that they want to share? Specifically, what I'm looking for is the value of this, 1 to 20 million. And what were the major factors? What are your thoughts on major factors
I
in
could
the
be totally wrong, but I think a major factor is the precedence of historical accidents. There's been settlements before. Look at those for context and see where they fell in a range. I would have no idea of range, but I don't know if that is something.
Yep, absolutely. So no idea on the range, but you think maybe known risk,
I would say less than a million or a mil because it was minor injuries only, right?
minor injuries, says minor injuries. Yep. There was a
And
2-year-old son in the back, sustained minor injury.
and does the fact that it was an illegal U-turn factor into the conversation?
It could, absolutely. It could factor.
Wha- What's the driving history of the employee and were they potentially impaired at the time of the occurrence?
No impairment and driver history at this point unknown. And one thing I want to point out is that kind of intentionally not giving you all the information. Oftentimes that's how we operate. We don't get all the information and we have to kind of make a judgment call on what we think it's worth and what number we want to try to settle the claim at.
So I'm also wondering, what was the policy of the agency? Was this child allowed to be in the vehicle?
So this is just this is not a government vehicle. This is just Joe and Sally Public. And they're making a claim against Washington State DOT, WashDOT, for road design. So I think we're kind of on the right track with known risk, one of the biggest factors was DOT knew that there had been a lot of crashes here prior, right? And that this particular stretch of road, 3 mile stretch of road, narrowed significantly, causing a hazard. And the fact that they later secured some funds to fix or widen the road, that was a major factor. So this claim ended up settling for $2.8 million. That surprise anybody? A little bit?
A little
No.
bit.
Yeah.
I thought it would settle closer to 5 million because of the kid being in the car. Like, I'm not surprised.
Yeah. Yep. And damages, severity of injury, damages plays a factor. And we'll see that in a little bit too. So
Does signage help or hinder in these types of situations when there's a known issue, such as obviously WashDOT was planning on, or the DOT? I won't say it's in Washington State, but the DOT is already has it on their radar to take care of. It's just a funding issue. Does signage help or hinder in these types of situations? Asking for a friend.
and I'm not a road design expert, so you may want to consult with an engineer or an attorney, but from my experience, signage, as long as it is the proper signage and it is a signage to alert of a potential hazardous condition, a warning, I don't think it can hurt.
I think along the lines of what Maya's thinking is fault. Like, did the agency driver get a ticket and they were 100% at fault? Because I think that really doesn't help the
Oh, right,
agency's case.
right. Yeah, that's a good point. That's a good point. And again, this is not an agency driving. It's just Joe and Sally Public driving along the road. They make the illegal U-turn, and ultimately they file the lawsuit against the state, and the state has to defend the design of the road being improper, potentially not meeting uniform traffic code standards. So that's why they settled this case.
Okay, thanks for that clarity.
Yeah. So let's move on to the next one. Again, city DOT, sorry for picking on city and DOT, but a motorcyclist traveling through an intersection with right-of-way was struck by a left-turning vehicle, resulting in catastrophic injuries. And I believe this was city specifically. So what we know about the incident, the intersection had a history of safety complaints. Plans had been developed to install a protected left arrow. Funding had been identified for the improvement. The signal modification had not yet been implemented at the time of this accident. The protected left turn arrow was installed shortly after the crash. So let's take a couple minutes, jot down some ideas on this one, maybe some factors we think were contributed to this, maybe what the value of this one is, how this could have been prevented.
The scenario that's up, it looks like the illegal U-turn one again. Sorry.
Yeah, yep.
Thanks.
I mean, whether or not a green arrow had been installed yet or not, it certainly seems like the fault is on the motorist that did not yield for the motorcyclist that had the right of way.
Yeah, I tend to agree with you. I mean, I would tend to agree with you. However, we know that's not always how a jury will look at things. And that's kind of the tough battle that we have to fight a little bit. We have to make that decision of whether we want to take it all the way to the mat and go to a jury trial or whether we want to settle it.
Does the fact that everything was already planned and designed and in process factor into the decision as well?
Yeah, I think so, because they've already identified the issue, right? And they're like, hey, we've got these complaints, we have a plan in place, we're planning to fix this using, this signal modification, protected left arrow, and we haven't done it yet. So that's all discoverable, right, in a lawsuit.
Right.
Hope to defend that.
Right. So if you're under design and getting bids together and getting the contract put in place, that's going to be a different scenario than the first one where it wasn't. It
Yes.
was identified but not funded, planned, designed, etc.
Yes. Different scenario.
Hi, Bryden.
Yeah.
Sam has a question. What would you say the general ratio is for settlements versus court?
Oh. So I'll just speak, broadly speaking, not many cases are taken to trial in Washington State because of the things that I mentioned. No tort caps, right? So a jury can award 100, 200 million, right? And that's the risk we run. Also joint and several liability. So in a road design case like this, it could be a single vehicle accident, right? With the passenger. And even though we know the driver shouldn't have been going 80 in a 25 when they hit the tree and, maybe really severely injured their passenger, they can argue, well, county, you should have had a guardrail there. So then things become more difficult because of joint and several, because we are in the boat with the driver. And if a jury finds the county 1% liable and said, hey, county, we're going to do you a solid, we're only going to put 1% on you. We think you did pretty much everything you could. Well, they're not really doing us a solid, right? If they put 1% on us because of joint and several, we could be responsible for the whole jury award. So that's how joint and several works. And that's why not many cases are tried. And for us, we've tried, it's probably over 95% of cases settled. We've tried 3 cases in the last probably 2 years. Some cases we also deny and they just go away sometimes, if there's not much to them.
Thanks, Bryden. We also have a couple of guesses in the chat. We've got 5 to 15 million and 20 million.
So we're thinking, so we got 5, 15, 20, somewhere. We've got a broad range.
David shared, fun fact, you're not supposed to roll forward into the intersection when you're having a blinking arrow because you will get a guaranteed turn arrow eventually. And people also run red lights at an alarming rate these days. So there's that. Yes.
Correct. Yep, correct. So just an FYI, a little bit more information on this one. So this was, again, I don't think it was mentioned, but it was 2023 when this truck made the left turn on the green, causing the catastrophic, potentially catastrophic injuries to the motorcycle rider. This one, the city manager, let's see, acknowledged, and we don't recommend you do this, but they acknowledged some inaction on the city's part. So, if you're going to make a public statement, don't, talk about the facts. Don't take responsibility for something, because that can come back to bite you. So this one ended up settling for 6.5 million. And within 1 month of this collision, the city began to install the left turn arrow.
Wow.
We were pretty close, right? 6.5 kind of had that range, but
Kara asked, I wonder what the laws say the state DOT responsibility is to keep roads safe and the definition of safe.
yeah, that the language that is cited often is safe for reasonable travel, I think is the language that is cited. And reasonable travel, that can mean a lot of different things. But some of the cases that we get, we often argue that 80 miles an hour and a 25 is not reasonable travel, right? Or being intoxicated, driving at 80 miles an hour, or 25. But we also get other cases that have some legitimate, bad facts for us, and where we're not following certain national standards, like the Universal Traffic Code for, how sharp a turn can be, what the speed limit should be, what devices, what signs should be there. So there's standards for those things, and we need to follow those in most circumstances. All right, last one. So this one is a teenage driver lost control and entered a freeway median. The vehicle rode up on an earth berm, effectively launching this vehicle into a concrete structure. This resulted in catastrophic spinal injury and partial paralysis to the driver. The median used an earth berm rather than the guardrail system. Earth berms have been identified for several years as not being effective in deflecting vehicles away. Funding had been allocated across the state. This is a DOT-related case. Funding had been allocated across the state to replace these earth berms with the guardrail system. The location had been identified for improvement. Work had not yet occurred. Similar berm locations elsewhere had already been corrected. So what do we, I'll let you guys think on this one for a couple minutes, and then we'll come back and talk about it.
Sam says 10 to 15 million, significant damage to the driver, identified known safety issue in that location. It didn't mention the speed of the driver or if they were intoxicated, though.
No intoxication, and driving at normal, reasonable speeds.
Yeah.
On the freeway, I-5 southbound. I don't know if you maybe recall this one on the news. I was actually working in DuPont when this one happened, but it happened right by DuPont on I-5 southbound.
Yeah.
In 2018.
Kara says, this one sounds like a big settlement because of major injury, more responsibility on the DOT due to lack of guardrail if no impairment. Sam says, I would say 15 million then, based on your response.
50? 50?
15 million.
Yep. Okay, 15. Gotcha.
Yep.
Okay. So we have a couple guesses here. Right around 15 million, right? I think is where both guesses, kind of the 10 to 15 range. Anybody else have any ideas on this one, on value? And then I know the known risk is a big one, right? Severity of injury as well. Any thoughts on any of that?
Kara goes with 22 million.
22 million.
Ellen says 0. And then Woods M. Basically, what I'm hearing from these scenarios is that if there is a wreck, grab an attorney and get paid by the government. No accountability of own actions.
That's not the takeaway here, but yeah. Sometimes we're very cynical in the claims world, so sometimes that thought does cross the mind sometimes, but no. We do get claims where we have absolutely done something wrong or not followed or breached a duty, basically, and people get harmed. We're not perfect, but that's why I want to talk about risk management. What can we do to prevent these claims? How can we prevent them from happening again? That's really, really kind of an important takeaway.
Yeah, absolutely. Thanks, Bryden. We have a couple more guesses. Nicole says 15 to 20 million. Barbara says 20 million or more.
Yep. Yep. You guys are really pretty spot on. This one settled for 28.5 million. And a big factor was the fact that the earth berms, it was a known issue, right? And DOT was already in the process of replacing them. And so immediately after this accident, they kind of rushed to get all of these replaced across the state because I think they saw significant liability here. Because the earth berm it launches a vehicle into, kind of into the median. It doesn't deflect them at all, really. Um, so
One of
that
the
was,
cha
yeah.
One of the challenging parts, and I obviously 100% feel for the individuals involved here, but one of the challenging parts is that all of us who work for government is you see this stuff and there's just not enough money to deal with some of it. And so you're trying as best as you can, and yet it's still not good enough. It feels like sometimes.
Yeah, absolutely. Absolutely. And yeah, we talk about this a lot with our member counties. I know counties are struggling a lot to try to make ends meet with their budgets, and they're trying to cut costs here and reduce the funding is reduced from the federal government all the way on down from the state. One of the things we talk about is, okay, if we cannot do the work to fix it, what can we do to alert the public of the hazard? Or at least try to prevent something from happening while we try to secure funds to fix it. And I always think about like a sidewalk scenario where you've got this big tree on the sidewalk and the roots are just pulling up, the cement basically to almost make it unwalkable. I'm sure many of us have seen this in where we live. And one of the things you can do is set up a barrier, right? That's low cost, and direct the public around that specific piece of the sidewalk. Maybe to a safer, definitely don't direct them onto the road, right? But maybe direct them around it. Maybe create a barrier. Like I've seen barriers kind of going out onto the road a little bit with cones and signs, just to avoid that hazard. So in the meantime, what can be done? What sort of risk management tools or techniques can we use to try to prevent something from happening while when we know about it and we can't fix it right away?
The city of Pendleton, Oregon has printed on their sidewalks, historic sidewalk, walk with care, or something to that effect. Is that effective? Or it was humorous to me. Yeah, it also made me think, oh, yeah, you're right. What could they do? Their entire sidewalk everywhere throughout the entire city was challenging.
Yeah. Yeah, and that's not going to be enough to prevent or defend a claim if a claim and a lawsuit is filed if somebody gets seriously injured. But it sounds like they know about the problem, and what you paint sidewalks, right? We know Washington, you spray paint a sidewalk, it's going to wash off in like 2 seconds, right? But with the rain, but you just have to keep doing those things.
Lou shared new route as an option.
New route, yep, absolutely. So,
And Ellen has her hand raised.
I have a question. Like all these cases involve acknowledged issues. What kind of happens when there's citizen complaints on an issue, but maybe the agency says, well, the construction of this area is in keeping with policy. So internally, there's no action taken when there are complaints. How does that change these scenarios to where, how much does the citizen complaints fuel whether the issue is legitimate, even if the agency does not acknowledge there's an issue?
they definitely, I mean, if enough citizens are complaining about a specific issue, I mean, if it's one person, I still think even one complaint, the agency has a duty to look into it, investigate it at the very least. It doesn't necessarily mean it's an issue, doesn't necessarily mean they need to do something, but when you start getting multiple complaints about the same issue, that's going to be a problem if a lawsuit's filed. because you're going to have to defend why you didn't do anything. And if you know anything about lawsuits, or if you've ever been deposed, it's really not very fun sitting on the other side of a table from a plaintiff's attorney trying to defend why you didn't take any action after receiving 10 complaints from the public, and then somebody gets, seriously injured. So yeah, that can be a problem. And we see that a lot. We do see that a lot. And so we train our counties to investigate, and we have a program actually where we can get an expert involved, potentially outside counsel, get a road expert involved if the engineer wants another opinion. And we can look at an intersection and try to determine, I just actually got one today where a county is getting complaints about too many speed bumps in an area. Now, I don't know how much of a liability that is, but we're going to look into it and see, see what the issue is. We're going to try to help them with that.
Thank you.
Yeah. All right. So this is kind of just interesting stuff. You may or may not know this, but this also makes it difficult to defend these cases. And one of the reasons why cases settle. A jury does not get to know all the information. So some of these accidents we're talking about, we don't get to tell the jury whether somebody was wearing a seatbelt in the car. And that's just established law. And that's the way it is in almost not every state, but many, many states. They don't get to know. So when somebody gets in an accident and suffers severe injuries and potentially was ejected from the car, we don't get to say, well, yeah, because they weren't wearing their seatbelt. We don't get to tell the jury. We also don't get to tell the jury or explain to them what joint and several liability is. So when I was saying, hey, we're going to do the county as solid, that's what the jury says, right? We're going to put 1% on the county here. They don't understand kind of the decision that they're making there. So it's kind of an interesting fact. We also, we cannot admit paid medical expenses. The jury only gets to know what was billed. So if you're staying at if they were airlifted to Harborview, and that cost, and they stayed in the hospital for a while, and that cost $300,000. That's what the jury sees. They don't get to see what was actually paid by insurance. So interesting. And all these things kind of, just kind of interesting things you may not have known. And if you're ever on a jury, now you do know. Any other evidence that a judge may determine is not relevant, right? We have motions in limine, and that's just a fancy way of saying what evidence can be admitted. And there's hearings on that prior to a trial. And a judge can determine, no, you can't talk about this. This is not relevant to the case. So. And then damages. So I just wanted to cover damages briefly. Special damages versus general damages. Specials just means medical bills, vehicle damage estimate, rental car expenses. Those are special damages. General damages are the intangibles, like your pain and suffering, a loss of reputation or some sort of personal injury claim, loss of consortium. Also punitive damages. And then I'm just going to skip this because I know we're kind of running a little low on time, and I want to get to this scenario because I know we wanted to talk about cyber. So this is another actual scenario, and it's actually a ransomware scenario. So a county public health employee attempts to log on to her computer at 6 a.m. on Friday morning, when suddenly a message pops up on her screen. The message looked a lot like the message below here at the bottom. And the message says that all county data is now locked. The county must pay for a key to be able to unlock their data. The demand from this ransomware hacker group was $1 million, and they said it needed to be paid in Bitcoin. And this actually happened to one of our counties. So I'll give you a couple minutes just to kind of think about this one, and then we'll talk about it, and we'll really get into some of the risk management on this. What could have been done to prevent this one? And I'll give you one more fact about this. A public health employee was one of the public health employees clicked on a phishing link, and that allowed this hacker group to gain access to the county's network. And they kind of stewed and kind of poked and prodded around in the network for a while before they found a vulnerability, and they were able to steal basically all the county's data.
Yeah, that is scary. Sam says, well, let's get IT to verify this is a real first and things are actually locked up. David says, was it really locked down? The Bitcoin is a red flag, not today, ISIS.
Yeah, fun fact about these hacker groups, they always want their money in crypto for whatever reason. And actually well, I do know the reason. The reason why is because you can put Bitcoin into what's called a mixer. Each Bitcoin has like an ID to it, a code where it can be tracked. But if you put it into a mixer with other Bitcoin, it spits out a random bit. You're basically exchanging one Bitcoin for another, and that makes it impossible to track that Bitcoin. So they want their money to be untraceable.
Wow. Lou says, hackers are crafty. Yes, confirm with the city and county IT teams and cyber teams first. And David shares, rule number one of cybersecurity, don't click random links, especially when they come from someone with a @gov.@yahoo.com or something silly. And Aaron shares, moving our data to the cloud and off of our aging on-site servers, better security and access for the city.
Yep. So what about this one? What do we think this one was worth? We actually settled this one here 4 years ago in our office. Any thoughts on value?
Sam asks, who would even be the claimant here?
So with a cyber policy, we have first and third party coverages. So first party coverage can be where, you're basically been attacked by another party and you need to recover a ransomware attack. You need to recover your data. So that's how cyber policy works.
Yeah, thanks, Bryden. Lou guesses 12 million.
12 million. So with this particular case, we alerted our cyber insurer, AXA XL, and what they did is they hired a law firm that basically their specialty is to negotiate with these hackers. And many of these hacking groups, they come from Russia and foreign states. They've worked with them in the past, actually. And so one of the questions we had is, well, how do we know if we pay a ransom that we're actually going to get our data back? Since they've worked with these groups so often, they know that they're going to release the data if they pay the ransom. So we were able to negotiate this down to $300,000 in Bitcoin is what this ended up being for the county. So not a catastrophic loss, but the downtime of not being able to access your data, not being able to provide the services to the public, that can be the big issue. And also sensitive data, right? Counties do have sensitive data, public health, auditors, that a lot of sensitive data. Other government entities as well, state, cities, of course, right? So what I really want to talk about with this is what could have been done to prevent it from happening. So it's really, really important for government entities to implement these cybersecurity controls. And back in 2021, when this occurred, many of our member counties didn't have multi-factor authentication. They didn't have segmented backups. And they certainly weren't, training their employees on phishing exercises or cybersecurity awareness training. They didn't provide that. So over time, we talked to our member counties, had them implement all of these 5 things, including endpoint detection and response, and making sure they were patching any vulnerabilities. And a patch basically is just where you download the latest version of software where there's a vulnerability in the code. You're just downloading the latest version. That's all that means. So we had them do all of these things, and it really has prevented any claims from happening since then. In addition to these things and implementing the security controls, it's really important that you test your incident response plan. So do you have an incident response plan? Do you have a business continuity response plan? Are you testing those? Do you have backups that are being tested? And obviously these go through your IT department. I don't expect you to know or be directly involved with these. Maybe you're directly involved with business continuity though, right? If something happens, what do you do? What is your role in that? And also use resources. So we encourage our member counties to use CISA, it's a government entity, MSISAC, it's another collaborative entity in the cyberspace, and also follow best practices, cybersecurity framework like NSIT. So those are really, really important things that government entities need to do. Anybody have any questions on that? One thing I did want to share now that we're on the topic of cyber is we actually have I have a cyber meeting scheduled with our cyber insurer tomorrow, and it's open to any government employee that wants to attend. Where our cyber insurer, she's the head of claims at AXXL, which is our cyber insurer. She's going to be sharing for an hour kind of what the cyber claim process looks like, and what a risk pool's role in that is, what the government entity's role in that is, and it's so if anybody wants to attend, feel free to reach out to me directly, and I can send you the information on that. But it is really informative if you have questions about like a cyber claim.
Thanks, Bryden. We did have a question, although this is going to be recorded. Kelly is wondering whether you are also comfortable emailing the slides so we can distribute it to the members
Oh,
for
yeah.
reference.
Yeah, absolutely. Absolutely. Yeah, happy to share.
Thanks.
Yeah. And I'm not going to cover this we're kind of running out of time, and I want maybe a little time for some questions if anybody has anything. But just so that you're aware, and I will share the slides, these are the most common types of employment liability claims that we get. And then included in this is this kind of case study for employment. And this is another case study that actually happened in one of our counties. And I said that we don't like picking on counties, but we do have, claims just like everyone else. So a county employee, I'll just quickly go over this here. A county employee who is new to the roads crew is alleging that while on duty, 2 roads crew members stopped at a gas station and purchased mini bottles of liquor. And you're probably thinking to yourself, who in their right mind would do? Well, it does happen, believe it or not, it does. And they were mixing the alcohol in their coffee, right? They had a little Irish coffee in the morning. Yeah. They tried to get the complainant to drink the alcohol as well. They were he was a new employee. I think they thought that, they could maybe manipulate him, coerce him maybe into participating in their shenanigans. And that didn't happen. So this new employee did the right thing. They notified the risk manager, HR director, the supervisor, and then the county basically got on that complaint right away, started to investigate. That's what happened. Well, I kind of just ruined the questions, but what would you guys do in this case? And how do you think this incident should be investigated? I guess is a good question. Because it took some detective work. What do you guys think?
I mean, first get proof of the claim, go to the liquor store, get the video, get the receipts, all that stuff, make sure it's
Yep.
legit.
Absolutely. That's exactly what they did. They got them on camera buying the liquor at the store.
Jen says, I feel like this is a recent example And Aaron says third-party investigation.
We did get a third party to investigate. It is a fairly recent example. Hopefully it's not too close to home for anybody. But it is our county, so one of our counties.
Perhaps review your HR policy to see what mitigation steps would need to be taken, including up to termination.
Yeah, that's a great question, right? After that kind of comes along after we get to the point where we've done the investigation, we have our findings. Maybe we're working with the union if they're a union employee. What's past practice with something like this? Does this, obviously this is very, very serious because they're in a county vehicle, buying liquor, drinking liquor potentially. Yeah, that more than likely it's going to rise to the level of termination, right? It's very, very serious.
We also have from M-Firms, test employees for alcohol, and then Kara says yes, if CDL, union contracts, etc.
Yep.
And then Sam says review any potential procedural language in the union contract if there
Yep.
is.
Yep, absolutely. Those are all great things, yeah. Any other comments, questions on this one?
Sounds like you kind of have a fun job of like hearing about all the crazy things. I mean, some of them aren't fun with the accidents, but like some crazy.
Yeah, sometimes we don't know whether to laugh or cry. And we always say, we're fighting a losing battle and we're just trying to lose the best way we know how. But yeah, we do, just amongst ourselves in the office, we do see some of these things and it's just, you just cannot make it up sometimes. You just really can't. With employment, I just don't understand why people can't get along. That's the biggest thing for me. Like, well, but people are people. Not everyone's going to get along. So again, this is kind of for counties, but it really applies to everyone. So the impact of employment related claims, legal fees, right? Settlements. It's not just financial, it's also reputational. You don't want to be the county that's on the news for something happening, for either making a bad decision or failing to act or having an incident be the subject of 7 a.m. or 7 p.m. on the news, right? It can also cause operational disruption, employee morale. If employee morale decreases, that can snowball. I think we've all seen that, right? If one or two employees, are impacting the morale, it can affect 3, 4, 5, 6 employees. It can affect everyone, really. So those can be kind of intangible costs, right, on the entity, on the government entity. HR, they have to spend a lot of time trying to manage these things, increase admin time and costs and oversight. And then policies, we often don't change our policies until we realize that, something happened and wait a second, that wasn't in policy or we need to change our policy. And we do get a lot of employment claims related to failure of hiring, training, all of those sorts of things. And for the taxpayer, we don't think about that, but this is taxpayer money, right? Coming from all of our government entities, it's all taxpayer money, right? Any claim payment from $1 is taxpayer money. We're 100% funded by our taxpayers. Just some proactive things here. Again, this kind of illustrates, hey, why can't we all get along, really? But anyways, proactive measures, employee training, regular audits, right? Those are huge. Promoting a positive workplace culture, pre-defense review, pre-litigation. I mentioned this briefly, but do we need to get HR and legal involved? Do they need to look into these things? Can we get outside counsel involved necessarily? So kind of at the supervisor level, right? But involving the right people to make sure we get the right outcomes is really, really important. So just takeaways. Risk management is key. Again, this all comes back to risk management. How can we prevent these things from happening? Everyone is a risk manager. It sounds cliche, but everyone is a risk manager. Utilize all the resources that are available to you. And I say this, don't be that guy or that gal But really, you don't want to be the one that's being deposed, right? You don't want to be the witness if you can avoid it. You don't want to be the subject of an investigation if you can avoid it. If risk management allows us to avoid those things. And the cost of claims are rising. So do your part in that. And that's all I have. So, whew, just right on time.
Thank you so much, Bryden.
Yeah.
If you have some time, you've got a lot of kudos in the chat. Thank you so much.
Absolutely.
And yeah, that was super engaging. We really appreciate you sharing your expertise and knowledge and also the real life experiences that you've had and sharing that with the mock trials.
Yeah.
We really appreciate it. So I'm not sure, do you want to stick around for questions or?
I'm available to stick around if anybody has questions. Yeah.
Great. And Terry shared in the chat. Terry, thank you for joining us from, I think, Tennessee, you said. Terry says, this discussion made me wonder how much tort liability varies across the nation, and wow, it really varies. I found this list informative and then included a liability chart there. Some states really limit governmental liability, while others have virtually unlimited liability.
That's a great point, and that's absolutely true. Absolutely varies from state to state.
And again, you've got a lot of kudos in the chat. I don't know if you have access to it, Bryden.
I pulling it up. Yeah, thank you. Thanks, everybody. Any other questions for me? And again, just reiterate. So, I do have, like I said, feel free to email me, reach out to me if you want to attend that kind of life cycle of a cyber claim tomorrow at 1:30 p.m. Pacific time. And I can send you that link. Hopefully it was informative for everybody. And thanks for having me.
Thank you. Thanks everyone for joining us today.
All right. Bye, everybody.
Thank
Bye.
you.
Bye, thanks.
Here.
Bye.